Much for having me. I've spent the last close to 41 years since I got out of law school thinking about housing justice issues very broadly. And when it comes to issues of housing justice for people with disabilities, I start with some very basic assumptions. One is that for the longest time in this country, and it's not over yet, people with disabilities have been shoved aside, disregarded, often thought of as less than. And the consequence of that is that we don't really have full community integration of people with disabilities. The Fair Housing Act was amended in 1988 to prohibit discrimination on the basis of disability in all housing transactions that are covered by the Act. And as we know, there's some exceptions for very small landlords, but the Fair Housing Act is not connected to receipt of federal funds, and it isn't, it doesn't have to, you don't have to run a governmental program in order to have to comply with the Fair Housing Act. It applies really across the board. The anti-discrimination requirements of the Fair Housing Act really are meant to move people with disabilities into the American mainstream. There's all sorts of manifestations. I'm going to talk about some of them today. I do want to just refer back to the case that Ian spoke of just a moment ago, which is Independent Living Center of Southern California versus the City of Los Angeles. Like many other governmental or city housing programs, affordable housing programs, Los Angeles had simply forgotten, neglected, disregarded the accessibility requirements that are built into the Fair Housing Act, the Americans with Disabilities Act, and Section 504 of the Rehabilitation Act. The ADA, of course, applies to state and local government programs. Section 504 applies to any program, any housing program that receives federal funds, whether it's public or private. And in that case, California, Los Angeles thought, of course, that it must have the most evolved accessibility standards on the face of the earth. And so they just didn't pay attention to the federal standards. The result was apartment complexes, literally 900 to 1,000 buildings and something like 70,000 total units, had doors that were too narrow, had thresholds that kept people with wheelchairs and other mobility impairments from getting into and using units. And literally, people were ending up in nursing homes because the affordable housing portfolio wasn't accessible. And the only place that they could find a roll-in shower, the only place that they could find a no-step entry, was in a nursing home. And we're not just talking about older people with disabilities, but people in their 30s were ending up in nursing homes as well. So I'm really passionate about the community integration, community inclusion provisions of the Fair Housing Act, and they could be used in very big ways, like in the Los Angeles litigation, but also in just day-to-day ways that really do expand people's housing opportunity. In the design and construction accessibility space, I've had lots of defendants, including City of Los Angeles, say, well, we were pretty close. We were just off by a few inches. Often those few inches are the difference between, being able to live well in the community in affordable housing, or being stuck in a nursing home, or perhaps even homeless. So the other thing too, just that's motivated me over all these years, is I hate bullies. And so often people with disabilities are bullied. They may not know their rights. They may not feel comfortable stepping up and trying to enforce them. They may not know, quite frankly, what allied organizations are out there that can help them. And certainly MCJ is one such organization. The private fair housing groups and legal services offices and centers for independent living and law firms like mine are all available to help enforce these rights. So with that, let me sort of launch you into what I think is the big picture here. I understand, that our hosts are going to be sharing or at least making available this PowerPoint presentation afterwards. So my contact information is in here, and there'll be some links and resources so that you might want to have this in electronic form in case you want to go back and refer to it again or look at any of the resources that I've tried to embed in the presentation. from the very sort of headline level, the idea of the Fair Housing Laws, Fair Housing Act ADA 504, is to remove barriers faced by people with disabilities. Forever, people were kept in the back rooms of their families' houses or the back wards of psychiatric institutions on account of disability. And when Congress amended the Fair Housing Act in 1988, it said no more of that. Right? We're going to really move people into the American mainstream. And when Congress, in a report on the meaning of the Fair Housing Act uses those terms, move people, end the unnecessary exclusion, move people with disabilities into the American mainstream. That's a powerful message about what national policy is going to be. Now, you may note here in this quotation from the House report, and maybe in the statute itself, and maybe you've heard the term used kind of broadly, handicap. And I'm going to say, I'm going to avoid that term wherever I can, except for when I'm quoting from the statute, the regulation, or the legislative history. Here, handicap is an old-fashioned term that's derived from what beggars used to do. They used to have their cap in their hand, begging for money on the street. So let's move away from all of the bad connotations of that term, and let's use the term disability. Because although the Fair Housing Act has not been amended to change that term, the ADA and Section 504 have used the term disability and define it exactly the same way. So let's use that term throughout. I talked about this in terms of community integration. Maybe we could also talk about it as full participation. The Fair Housing Act requirements grow out of this commitment that the 70 million or so people in the United States who qualify for that civil rights definition of disability should not face architectural and attitudinal barriers. And what I mean by architectural barriers is the way units are built. The problem in Los Angeles was the architectural barriers that were built into the development of those affordable housing units, not just 60, 70, 80 years ago, but units that were being built in 2012 when we filed that lawsuit were being built wrong. There were architectural barriers. The attitudinal barriers maybe are more difficult to get our arms around or to eradicate. But those kinds of barriers are the thought that, oh, you poor dear, you have a disability. Let's be charitable to you. And that's not at all about what the civil rights laws are meant to be. They are, in fact, a legal entitlement. They are a civil rights law that gives you a right to be treated in a certain way and protection from discrimination. So very broad aspirations here. I think that there are a number of principles embedded in the Fair Housing Act. And so when I talk to you in a few moments about some of the specific provisions about anti-discrimination and reasonable accommodation and modification, they are all fed by some of these really basic principles. And if we can understand what the law was trying to get at, then when we start talking about some hypotheticals, which we will do later in this presentation, and I hope I both get questions from the audience, but also that when we come to the hypotheticals, that folks in the audience are willing to maybe use some of their fair housing knowledge, whether they've had it all along or whether they acquired it today, to solve some of the problems about how does the Fair Housing Act apply. The first major principle is this idea of equality. People with disabilities should have an equal opportunity to live in and participate in the community and to be treated the same as people without disabilities. So when we think about the Fair Housing Act and when we think about other anti-discrimination laws, the idea is, treat people the same or don't treat them differently on the basis of their protected class. In the context of race, a real estate agent, offering for sale or rental properties should not treat a black family worse than a white family because of race. In the same way, that person should not treat a person with a disability differently, either less favorably or in any patronizing sort of way. But the idea is disability is a protected class. It can't be the basis for differential treatment. So equality is the first principle. The second, I've talked about it already, is community integration, but The very same motivating principles that are behind the race and national origin anti-discrimination laws in this country, the principle of integration, which is people are entitled to live wherever they want to. There are no black neighborhoods and white neighborhoods. They people may choose to live voluntarily in neighborhoods that are characterized by a certain racial, ethnic, or other population. But nobody who controls the availability of housing should be steering them or restricting them in any way. Similarly, people with disabilities should be fully integrated into the community. They shouldn't live in nursing homes because when you live in nursing homes unnecessarily, you are cut off from community life and other community services and activities. So equality is the first principle, integration is the second. Choice, I think, is very closely related to those two, and that is it's up to people with disabilities where they're going to live, not up to somebody else. Not up to the landlord who says, I'm not going to rent to you because you use a wheelchair and I'm worried that you're going to have trouble getting out in case there's a fire in the building, right? There are life safety rules meant for the benefit of all people who are tenants with and without disabilities. And so it is not up to a rental manager or real estate person. For that matter, it's not up to a local zoning and land use authority to decide where housing for people with disabilities should be. Whether we're talking about simply, plain rental housing that meets the requirements of the Fair Housing Act with respect to accessibility, or the highly accessible housing that's required under the ADA and 504, or for that matter, where group homes can be located in a community. A group home that provides housing for people with intellectual disabilities or people who are recovering from drug and alcohol dependence. All of those are instances where people with disabilities should choose where they want to live and not have that choice restricted by discriminatory or patronizing third parties. Lastly, and we'll spend a lot of time on this today, unlike the other anti-discrimination protections in the Fair Housing Act, on the basis of race, color, religion, national origin, and sex or gender, and familial status, people with disabilities have an extra added layer of protection. And that has to do with the concepts of reasonable accommodation and reasonable modification. Unlike the other 6 protected classes, people with disabilities are entitled to have things a little bit different when that different service or activity or different terms and conditions are necessary on account of disability. So that whole concept of reasonable accommodation, which I assume the audience has heard of before and may be very familiar with, grows out of this idea that people have to be treated individually. One of the things I often encounter, particularly when I'm doing training for housing providers, is the idea that they've heard in training previously that you have to treat everybody exactly the same all the time. And when you don't do that, you may be guilty of discrimination. And I would say that for the other 6 protected classes, maybe that's a rough rule of thumb. In the context of disability, you have to have a slight reorientation, which is to say you certainly can't treat people worse on account of their disabilities. You might have to treat them a little better if doing so is necessary to help them have an equal opportunity to live in and enjoy your housing. When we get to the hypotheticals and some of the other material coming in the next several slides, you'll see some practical applications of that. I talked before about 70 plus million people meeting the civil rights definition of disability. And I just want to contrast that for a moment because I think we all know people who have Social Security disability income, and that's based on having worked for some period of time in their lives and then no longer being able to work on account of disability. And if you've paid in enough to the system, then you might get a disability check every month. And, let's say you had a really successful career, maybe your disability check is $3,500 a month. You probably also know of lower income people with disabilities who may never have had substantial work. So they don't qualify for the benefits that you get by paying into the system, but they get something called SSI disability, supplemental security income disability. It's kind of a poverty disability benefit. And I haven't looked to see what the benefit is in Mississippi, but nationwide, very few people get SSI disability benefits above $1,000, and maybe it's nobody. Sometimes there's a state supplement that gets you a little bit above, but if you thought about what it took to pay rent in most communities, an SSI disability check isn't going to get you very far. Together, the SSI and SSDI programs probably provide benefits to about 12 to 15 million people in the country. And in order to get those benefits, you have to be really, really disabled. There's no other job you can do. Your condition is expected to, last for your entire life or end in death. So it's a pretty high bar to get those benefits. And in my old days as a legal services lawyer, I represented people against the Social Security Administration trying to get those benefits for them, and it was often very hard. Um, the definition of disability under the Fair Housing Act, ADA, and 504 is much more forgiving, is much more inclusive. So anybody who has a mental or physical impairment that substantially limits one or more major life activities will qualify. Anybody who has a history of that impairment, let's say you had cancer 5 years ago, now you're in complete remission, you don't have cancer anymore, but a landlord says, I'm not renting to you because you had cancer 5 years ago. You are a person with a disability, even though you don't presently have it, because you're being treated differently based on the history of having had a disability. And there's one other category, which is if somebody mistakenly treats you, regards you as if you have a disability, even if you don't, and treats you less favorably. Uh, you're a gay man. I think you have HIV on account of your being gay, and therefore I don't want to rent to you. Person doesn't have a disability, never had a disability, but is being treated as if he did wrongfully. So when you put those three categories together, the Supreme Court estimates that there are more than 70 million people in the country who meet that definition. It is the largest minority group in the country. And as I sometimes say in presentations, it's the only protected class that any one of us could join at a moment's notice. We get an illness, we get an injury of some sort, we're in a traffic accident, and all of a sudden we have joined the club. And I think that when you think about that, if 1 in 5 people with disabilities qualifies, 1 in 5 Americans qualifies as a person with a disability, you understand the importance of both knowing your rights under these laws and also figuring out effective ways to enforce them. I've given some examples sort of abstractly, but I want to talk about just a couple of cases that my firm has done. A few years ago in central New York State, a realtor decided that she was going to terminate a family's lease of a single family home because the daughter had autism and a seizure disorder. And the realtor, when she learned of those things, decided the daughter ought to be closer to a hospital than 25 miles away, which is where the house was. And so the realtor terminated the lease. She did so based on the child's disability and treating her, less favorably. But she also did so based on the assumption that a person with a disability can only live in certain places, as in within 25 miles of a hospital. We took that case to the U.S. Court of Appeals for the Second Circuit. It settled for a substantial amount of money, and we have a published 84-page Second Circuit decision about all the things that the realtor did wrong and how the federal courts in the Northeast of the United States ought to be interpreting the protections of the Fair Housing Act. Some years ago as well, my firm handled a case on behalf of Pathway Homes. This is a mental health community services provider that gets people out of institutional settings, like psychiatric hospitals and training centers, and moves them into community-based housing. And it master leased about 60 units in an apartment complex in Northern Virginia. Things have been going well for 5 or 6 or 8 years, and all of a sudden, one day, the management company woke up and said, we're terminating all of these leases. Clearly, it was because of the disabilities of the people served by Pathway Homes. We went into court. We stopped the evictions. Pathway Homes continues to rent those units from that community, from that apartment complex. It continues to provide the services in the community rather than in institutional settings. So other things that are forms of intentional discrimination, you use a wheelchair. I think I'm going to charge you higher rent or a higher security deposit because I think you're going to ding up the walls. It could be a form of discrimination. I'm not renting to you because you have a service animal or a support animal. Again, differential treatment on the basis of disability, that could be characterized as intentional discrimination. Or as I referred to earlier, the idea that group homes can't be in certain zoning districts. Again, we've litigated cases establishing that that is a form of a disability, discrimination. There's another way of proving discrimination on the basis of disability or other protected classes, and that's this idea of disparate impact. You've heard a lot about it lately. The Trump administration says it's a fiction, it doesn't really exist, but federal courts for 45 years have found that disparate impact discrimination is illegal under the Fair Housing Act. So if you had a blanket rule that affected a certain group of people more harshly, and there was not a justification for that harsh treatment, or there was a lesser step that you could take without having that same harsh treatment, those are rules that will have to fall based on disparate impact on the basis of disability. So if you say no animals or no service animals, it's kind of facially discriminatory against people with disabilities, but if applied sort of uniformly, what it means is that the only people who are going to be hurt are people with disabilities as opposed to people without disabilities. So it's differential treatment. If your concern is, animals, do their business in common areas, well, then you should have a rule that says, and you should clean up after animals who do their business in common areas rather than banning them entirely. There is a less discriminatory alternative that gets you to your objective. And I've listed some other examples here. Independent living requirements. You can't move in here unless you can show us that you're able to live on your own without any assistance. Form of discrimination based on disparate impact. A requirement that any criminal history will disqualify you from living in rental housing. Again, that probably has a disparate impact on the basis of race and national origin and perhaps on disability as well. Let me move on, if I could, to the things that are unique in the protections under the Fair Housing Act for people with disabilities. The concept of reasonable accommodation. The law says pretty explicitly that a housing provider has to change rules, policies, and practices when doing so is necessary for a person with a disability to have an equal opportunity to live in and enjoy the housing. A reasonable accommodation is something that changes, as it says here, a rule or policy, not a tangible thing. I'd like a wider doorway to get my wheelchair through your old building. Maybe a request for a reasonable modification. So if you just think about those distinctions, accommodations typically intangible things, modifications usually some physical change or manifestation. The accommodation, in order to get it, has to be requested. So if you're a person with a disability who needs a reserved parking space, let's say, landlord, rental manager is not expected to read your mind. You have to ask for it. I have a disability. My doctor tells me I can't walk more than 20 feet. I'd like to have a reserved parking space in front of my unit or as close as possible. Okay, there's the request. The request can be made at any time. You don't have to make it before you move in. Your condition may arise after you move in which case you could ask for it at the time the need arises. And the decision about whether to request an accommodation and what it is goes back to that principle of choice. It's up to the person with a disability to decide if to ask, when to ask, and what to ask for. Once the request is made, a landlord has to respond in a timely fashion. So a failure to respond or dragging it out too long will end up being a violation of the reasonable accommodation mandate in the Fair Housing Act. The tenant is entitled to an accommodation that addresses the underlying need. So I used the reserved parking space example just a moment ago. Let's play out that hypothetical a little bit. I can only walk 20 feet. I'd like to have a parking space that's immediately in front of my unit. Well, maybe there isn't a space there. Maybe the closest space is 35 feet away. As a practical matter, the landlord and the tenant are now required under the Fair Housing Act to have a conversation. If I can't give you exactly what you've asked for, is there something else that can be equally effective or close to equally effective to allow you to do what you need to do here? So I sometimes say a person with a disability requesting an accommodation is not always entitled to like the Cadillac of accommodations, but is certainly entitled to the, like the Chevy of accommodations. It's got to be effective at addressing the underlying need. Talked about an interactive process. The courts have said that if the initial request is denied, the provider has to like engage in an interactive process. Is there something else? Is there an accommodation, an alternative of some sort that could be made? And that process really is intended rather to be a back and forth. Courts have said that reasonable accommodations, you can't just look them up in a chart somewhere and decide yes or no. Every one of them depends on the circumstances facing that particular tenant and that particular housing provider. A mom and pop building with 4 units is going to have fewer obligations in terms of modification or accommodation than a landlord who runs a 500-unit building. That larger landlord, more sophisticated, more resources, more alternatives, more ways of addressing the problem, more will be asked of that person. At the end of the day, if there is no resolution arrived at, it is effectively a denial. We can't do what you're asking for. And when there's a denial, the tenant needs to decide what comes next. The tenant could say, I tried, I couldn't get what I want, I'll make do with what I have. Or the tenant could say, I'm going to treat this as a violation of my rights, and I'm going to complain that I've been denied a reasonable accommodation. Probably should have put this tennis court up a moment ago to sort of describe the interactive process and the process basically of asking for accommodation. So let me play this through a little bit. Tenant is required to serve the ball. The ball has to land in the right part of the court on the landlord's side. That is to say, the request needs to be made. It should articulate why it's necessary and why giving that accommodation will actually ameliorate or lessen the effect of a person's disability and make it more likely they can enjoy and be able to live in that particular housing. So if you make that request, let's say you do it in writing, I need the accessible parking space, pretty close to my front door because I can't walk more than 20 feet. That's a decent request. It gets into the service court. The landlord now has to hit the ball back over the net. One of the options might be, tell me more about it. Can you show me some evidence of this? Well, now, if the person uses a wheelchair every day, it's about as plain as the nose on her face that she qualifies as a person with a disability, and that if she's using a wheelchair rather than walking, pretty conclusive evidence. Let's say it was less clear. The landlord is entitled to some evidence. Connect the dots for me, please. Show me how you need this, why you need this. Let's have a discussion about what, will work for you. A landlord who does that has hit the ball back over the net. Now the ball is in the tenant's court, and the tenant has to come up with some additional information. The landlord who says, we don't make changes for people with disabilities, hits the ball into the net. That is a violation of the reasonable accommodation provision. So keep that concept in mind as we talk a little bit further. I'm going to give a handful of examples here, and then we are going to move soon to some hypotheticals. And so I hope that people are are willing to come off mute when the time comes and participate in this conversation, because my guess is you'll know these answers, and we'll have some, I think, interesting and useful discussions. So, what kind of accommodations are easy? The tenant who says, or the applicant who says, I have a visual impairment or a learning disability. I can't read your lease or I don't understand it. I'd like to live here. Can you just like read it to me and tell me what's going on? Can you answer some questions for me? That's a pretty low level request. It doesn't really take much of the landlord's time, and it doesn't impose any financial burden anybody can see. And it's not, way out of the ordinary of what rental managers do, which is they engage people and they try to get them to sign leases and they get them moved in. Uh, Similarly, somebody with a cognitive disability who wanted to help filling out the application. The existence of a no pets rule, but somebody comes in and asks for a companion animal or an emotional support animal. Somebody with a visual impairment says, if you're going to send me notices about, like when the exterminator comes or when you're going to do an inspection of my property, could you put it in large print because I can't see the small print? Again, simple request, not a whole lot of burden attached to it, not a fundamental change in what the rental manager does. Here's one that's a little maybe more complicated. Somebody is a wheelchair user. Person who uses a wheelchair is more likely to not get to every single corner of the apartment, right? There'll be some tight passages and there'll be furniture placed in certain places. And so, maybe there's more wear and tear on the carpet in the places that the wheelchair, goes most often. Well, that's also going to happen, with somebody who doesn't have a wheelchair, and eventually there's going to be wear and tear. So, how about the request as a reasonable accommodation that a landlord recognize that a wheelchair user is going to have different kind of wear and tear, and maybe not, charge to replace the carpet every year or two? Why not treat that person more like, a valued tenant? And if there's damage, that's one thing. But if it's wear and tear that's different on account of disability, waive the extra charge for replacement. Somebody who has an allergy or multiple chemical sensitivity may say, listen, pest control things or cleaning products, could you do things that don't have a scent, that aren't going to trigger my respiratory problems? A no smoking sign posted in a policy, again, to protect people who are sensitive to chemicals or to smoke. Okay, we'll move to this separate category of reasonable accommodation, which I think causes a lot of consternation, which is animals. People with disabilities sometimes rely on animals in order to help them live well in the community. Even when I was growing up, people had seeing eye dogs, and everybody kind of thought, oh, I get it, seeing eye dogs. Over the last 50 years and more, science has shown more and more that animals can be helpful to people with disabilities. Have people heard of a hearing ear dog? A dog that helps somebody who's hard of hearing or deaf alert to certain sort of things, a doorbell, a smoke alarm, whatever the case may be, helps get that person to safety. Okay, well, maybe that's new to some of us. How about a seizure alert dog? There are certain breeds of dogs, including, I think, German Shepherds, who can sense the smell when somebody is having a seizure coming on because there's a chemical change and an odor associated with it. The humans don't detect, but apparently trained German Shepherds can. Emotional support animals, people who have anxiety about being in public places, sometimes are calmed by the presence of an animal, even an animal not trained to do anything in particular, like be a guide dog or a hearing ear dog, but simply the presence of the animal is soothing. There's been a lot of litigation on this, and I know that in the housing provider community, in the condominium and co-op association community, there's an awful lot of talk about these sorts of issues. And, as I said, we'll do some hypotheticals. We'll work through some of those things. The fundamental teaching of the courts that have heard these cases is that support animals and service animals are not pets. If they provide a service or if they provide emotional support, the Fair Housing Act has said pretty uniformly, they're not pets. They are an adjunct to a person with a disability. They are an agent of that person to help him or her live more successfully in the community. There are some resources, and again, if you get this PowerPoint, feel free to sort of tap into them. I worked at the Bazelon Center a really long time ago, but I wrote one version of what fair housing means for people with disabilities. It's a comprehensive booklet that's got case citations and lots of helpful conversation about these issues, and it's available now for free at the Bazelon Center website. And I think it was 2004 or 5, I wrote the first version of the emotional support animal fact sheet. To this day, it is the most requested or most downloaded thing on the Bazelon Center's website. So I guess it had some value to people in the community. And quite frankly, I think it tries to just lay out the facts of, how the law applies in this particular circumstance. I want to take just 2 more minutes before we go to the hypotheticals to point out a couple of other areas where the concept of disability and accommodation may arise. Section 8 vouchers and things that look like them are a way for people with low incomes to afford to live in decent rental housing in the community. There's no federal protection if landlords choose not to accept voucher holders. There's no claim of discrimination available under the Fair Housing Act. Many states and localities have now started to adopt those additional protections so that people with disabilities who are often poor because of their disabilities qualify in large numbers for Section 8 vouchers and equivalent subsidy programs. And so when somebody with a disability walks in and asks a housing provider to enter into a lease based on that person's disability and receipt of Section 8, and as an accommodation, even if you didn't normally accept Section 8 vouchers, I'd like you to do it for me as a reasonable accommodation, raises a really interesting question, right? We said before that people with disabilities, through the accommodation mechanism, might get slightly more favorable treatment. You can imagine how the theory goes. I am poor because of my disability. That means I can't afford to live in the private rental market. I've qualified for a Section 8 voucher. If I can't use it, I may end up in a nursing home. There may be no place for me in the community. So I'm not asking you to change your rule generally. I'm asking you to change your rule in this one circumstance for me based on my own facts and circumstances. I think that's a really interesting conversation. I don't know what the answer always is going to be because every accommodation depends on the facts and circumstances of that particular case. But I think we should ask ourselves whether accommodation is strong enough to get past that kind of blanket policy. I've mentioned some jurisdictions have source of income protections. Almost all of them, where they have been litigated, have been upheld and have been a benefit to people with disabilities. Okay, on very quickly to modification. When the Fair Housing Act amendments were passed in 1988, Congress did not require landlords to go back and fix old buildings and make them accessible. New apartment-style housing after 1991 did have to meet certain basic requirements, right? Doors wide enough, bathrooms and kitchens usable. But there's no requirement to go back and fix pre-1991 buildings. Congress put in this savings provision, really, which said a person with a disability can ask for physical changes to her unit or even to the common areas if it's on account of a disability. Under the Fair Housing Act, though, that person has to pay for or find somebody else than the landlord to pay for those modifications. So the ramp or the wider doorway or the grab bars or the other things that were not required to be incorporated into older buildings can be reached through reasonable modification. Again, the downside, tenant pays. If it's a building where there is federal funding, the rule changes, which is to say, landlord has to pay the reasonable costs of modifications. So even in an older building, landlord, the obligation is likely to fall on the landlord. There are some conditions, and if people have questions about that, we can go into it in the question and answer session. In modifications, the landlord could ask for certain things along the way, make sure that the work is done in a workmanlike fashion. Um, if it's the kind of thing that needs to be taken out when the tenant moves out at the end of a lease, the landlord can ask for a security deposit, basically, an escrow amount to make sure that that change gets made back to the previous condition. And now I am finished with my talking at you part of the conversation. And I'd like to just pause and see if there are any questions before we go to the hypotheticals, or any comments that folks would like to make, and we can engage broadly on any topic that I've covered or anything of interest to you before we go to the hypotheticals.
And I would like to note, Michael, to tell everyone in attendance that everyone now has the ability to unmute their phone for the hypotheticals, and also if they have any questions. So you should be able to do that now if you have any questions before we move into the interactive portion.
And if you'd rather type into the chat, I'm sure that'd be okay too if you have a question.
And Ian, if that were to happen, would you read it out to me? As you're thinking about whether to raise your hand or join in, think of it this way. How often do you have a lawyer working for you for free with some additional time during the presentation?
I have a question. This is Regina from Kansas City Housing Authority. Can you hear me?
Yes, go ahead.
Okay, I'm sorry. If a resident is not living in a handicapped unit and has fallen ill for some reason, has to come home in a wheelchair that will not fit through, I guess what they say, a standard size front door and bedroom doors. And I guess the question would be, is that a reasonable accommodation to go in and redo the doors to accommodate that resident so that they can get in and out of the unit because they are in a wheelchair now? Or because we don't have a handicap unit available at the time?
Okay, so let me do my best to unpack that. There are certain units under the 3 laws that we've talked about that have to meet certain accessibility requirements depending on year that they were built. So if there is a designated, let's call it accessible unit rather than handicap unit, just so we stick with what I was saying before about use of the term.
I'm sorry.
No, not at all. And HUD still, uses the term. So I'm not slapping your wrist, I promise. So some units are designated as being more accessible than others, right? So under the Fair Housing Act, there's 7 pretty simple requirements. As I said, those are just in the post-1991 buildings. But, in public housing or housing funded with federal funds, certain units have to be made highly accessible. Sometimes they're called UFAS units, sometimes they're called Type A units, sometimes they're called accessible units. So if the person comes home in a wheelchair and she's going to be in a wheelchair for some short period of time, that circumstance is different than if a person is going to be in a wheelchair, for a longer period of time. So I think just from an operational point of view, somebody who's going to be in a wheelchair for, say, 5 days raises a different circumstance than somebody who's going to live there for the next 10 years. If it's the latter circumstance, then I think, yes, if all the accessibility that the person needs is the wider doorways, and none of the other requirements of the UFAS Type A or highly accessible units, then the modification is likely sufficient. That may be all that is necessary.
Mhm.
However, if the person, let's say that it's a condition that's going to, last a long time, it may be now that the tub is inaccessible, in which case widening the
Yeah.
doorways is a good thing. It gets the person in to the unit, at least in the short term. But, if she's going to take a shower, she's going to maybe need a roll-in now. And
Mhm.
it's going to be hard to modify a standard unit to put in a
Okay.
roll-in shower, in which case maybe another thing that has to happen here is that she needs to be prioritized on a transfer list for the accessible units or a
Okay.
waiting list of some sort.
Mhm.
But I think your
And
analysis is basically right. And if it is public housing or federally funded housing, the cost of that modification would fall on the housing provider, the landlord.
housing provider. And that would also include the commode as well.
Uh,
Everything in the bathroom, kitchen area.
Yeah, and again, I think you should be driven by what the person is asking for, right?
Mm-hmm.
If
Right.
I came home unexpectedly in a wheelchair and I'd lived in my unit for 5 years and I'd set up lots of things in my unit the way I liked them,
Mm-hmm.
I may not want to be yanked into a fully accessible unit, particularly if I
Yeah.
didn't need all the other features.
Mm-hmm.
And I don't know that I'd want my place torn up to have the commode changed if I didn't really need the commode changed, which is
Okay.
to say, let the person with a disability guide you in what she
Mhm.
needs, as opposed to assuming ahead of time.
Okay. Got it. So what if there, I'm sorry if I'm interrupting. What if there are 8 to 10 residents out of 50 that are complaining about the commodes being too low, and they all want tall toilets? That's a reasonable accommodation for them
I would
all.
call, yeah, I would call that a modification.
Modification. Okay.
Right. And so if a person came forward and said, I need a taller commode because, the
Uh-huh.
ones that are low, I could get on, but I can't get off. I assume
Yeah.
that's sort of what people are saying.
Mm-hmm.
Then I think, obviously your resources are your resources, whether you are public housing or private housing, doesn't matter.
Yeah.
There are only so many that you might be able to do at a time.
Mm-hmm.
So as long as you had an approach that began to address the needs over a reasonable period of time through the reasonable modification approach, I think that would be acceptable under the Fair Housing Act and under Section 504.
Okay. Thank you. I'm still kind of getting used to modification and accommodations. I'm still, getting ready, used to that rather. Determining what's what.
Yep.
Mm. But
Other
thank you.
questions?
We have one from an individual named Bridget, who I believe is my sister. And she asked first, is substance use disorder ever recognized as a disability?
Uh, I could go real deep on this, but I'm just going to give a top line answer. The answer is yes, provided that it is not what the law calls current use. So somebody who has, an addiction disorder, and from what we know about addiction, it is a lifelong condition. You could be sober, that is, you could not be involved in, controlled substances, but still be a person, with an addiction disorder. As long as you're not currently using, you are protected because Congress wanted protection so people could get clean and sober and, live in the community and not have this sort of held against them. Um, it can get really complicated when you talk about, well, what happens when people are in sober housing or drug-free housing and they relapse. But rather than get into all of that, top line, yes, it has been recognized, provided that it isn't ongoing.
And the second part of her question was, I work with individuals with severe mental illness, schizophrenia, bipolar disorder, etc., many of whom are on SSI due to their illness. What, if any, reasonable accommodations or modifications have you seen for these kinds of severe mental illnesses?
The circumstances, I've seen two just sort of off the top of my head. And so one is, we talked about emotional support animals earlier, and emotional support animals are often relied on by people who have anxiety, depression, PTSD, etc. So not knowing precisely what Bridget's clients are dealing with, the idea of an animal being part of a therapy program, part of the reasonable accommodation path to allowing people to live in the community and to thrive in the community, would be one approach. The other is just the availability of whether you call them personal care aides or whether you call them outreach workers, et cetera. I do a lot of work with homeless people in DC um, who have complicated histories, involved in chronic homelessness, who are supported by a team of people who do something called assertive community treatment. So they don't live in the unit, but they're there as frequently as the client needs them to be in order to, sustain themselves and get over crises and things like that. So the presence of outreach workers or personal care aides beyond the time that would normally be allowed in, rental housing is also one other thing that I've seen used as a reasonable accommodation to sustain people in community-based housing as opposed to letting them, go into crisis and then end up back in an institutional setting. Other questions or comments? Should we talk about my friend Bob? Hypothetical number one. So Bob goes to his therapist. His therapist says, Bob, you got to think about, getting a little dog. That'll help you. Maybe we could wean you off some of your medications, or maybe I'd have to see you less often, hearing you complain about things if this dog was in place. That is to say, therapeutically appropriate intervention. So Bob goes to his landlord, and the landlord says, nope, can't make an exception for you. We've got a no pets policy. Anybody think uh, that Bob's landlord is in the right here? Anybody want to take Bob's landlord side of this argument? Okay, I'll be Bob's landlord. Somebody else has got to argue for Bob's side, though. Okay, somebody's got to come forward. If I'm going to come forward and do this thing, which I feel very uncomfortable about, then somebody else is going to come in and talk for Bob. Okay, so I'm Bob's landlord, and I'm going to say this. I've been in this business 40 years. And let me tell you, the only bad tenants I've had here are tenants who sneak dogs in here. And I've been reading in the news a lot about, emotional support animals and, people who bring ostriches on airplanes saying that they're emotional support ostrich to get them over the anxiety of flying. And, I think this is all a crock. And that's why I've got this policy. I never make exceptions, and I'm not going to make it for you. Okay, who's Bob's lawyer? Who's Bob here?
For the sake of time, I will do it this time. Well, we're going to hope that someone participates for the next hypothetical. As Bob's lawyer, I will argue that Bob will need the animal for an emotional support. He has a mental disability, and for this dog, it will help ease his emotional support, and there is a federal Fair Housing Act in play.
That's good. Here's some things I would add. I'm happy to, Bob might say, I'm happy to comply with, all these rules. What's your concern? I'll take him out. I'll walk him, right? I'll make sure he doesn't pee inside. He's well trained. Here's his obedience certificate. Um, said politely, of course, it's no skin off your nose. That is to say, he's not going to be a problem. It won't be an undue financial or administrative burden on you, landlord. And it doesn't fundamentally change, what you're doing here, which is to say, you're not making an exception for all dogs. It's exception for one, for me, and that's because of my disability. So, we can manage this, not a big deal. Let's see if they get more complicated. So Bob doesn't go in the front door, basically. Bob's been living there for a while. And the stress of living there, and it's like it's really getting to him. Um, 3 months into his living there, he's got to check himself into the hospital. And he doesn't say anything to the landlord. Landlord finds out that Bob is in the hospital and said, Bob, you got to leave now because if I had known that you might have to go to the hospital or that you had a history of hospitalization, I never would have rented to you. Can this exist given the protections under the Fair Housing Act?
No.
Ashley,
There wasn't
let
me.
somebody.
Nobody
Oh,
else
it wasn't. Okay,
participated.
it was somebody else. Sorry.
Oh.
Ms. Smith, could you tell us a little more?
Yeah,
Why not?
finish the thought.
Okay, so I'm gonna say, am I coming to Bob's defense or I'm
Yeah, you
speaking
should
on
defend Bob here because we all know what the
I'm
landlord's going to
defending
say.
Bob. Well, under the HIPAA law, Bob felt like he didn't have to disclose his disability to you up front, and we do apologize that he didn't do that. But for the sake of Bob getting better and really wanting to live on his own, um, with the laws that are in place for his situation, we would probably have to get a lawyer to fight that because Bob, you're evicting him on the account that he has a mental illness, and it's not fair.
And also, Bob had paid his rent for the
Uh-huh.
month. So,
Yeah.
and this just happened to happen. And so the fact that Bob had paid his rent, it wasn't like Bob hadn't, he was doing his part of the contract, paying his rent and doing as a regular tenant would do. So Bob was doing what he supposed to do. He just felt as if saw himself getting sick. So he was trying to get himself some help. And that had nothing to do with where he was living and his living circumstances.
Excellent. I love this. Bob's going to be okay here, I think. Okay,
Yeah,
let's see what
Bob
else.
will.
Let's see what else we got going on here. So same facts from before, but turns out Bob thinks, okay, maybe I can't return to my unit. This hospitalization thing's going on. I'm too stressed out. So I'm in a year's lease, right? That's what the previous part of the hypothetical provided. Bob says, I can't return, and I'd like to have you let me out of the rest of my financial obligation. Landlord says no. She'd lose too much money. Does that is that right under the Fair Housing Act?
No. And the reason why I say no, because and another question, did Bob have a month-to-month lease?
No, this was a year's lease.
A year's lease?
Yeah. So he's asking, let's say, what did we say in the previous slide? 3 months goes by. So he's got 9 months left on his lease. And he's saying, cut off my obligation. You, landlord, you take the loss.
Is it an option where Bob can maybe buy out of the lease, or is it not stated?
This hypothetical says he wants to walk away.
Oh,
I would think that being that he is disabled, that he's on a fixed income. So to me, it would be more feasible for her to let him out of the lease because he would be losing, and then you don't want to put Bob in a situation where he has um, nothing left, and then he starts spiraling further and further into whatever he has going on, you know. And she could easily in 30 days um, get
Rent the
somebody
apartment.
to rent the unit
Mhm.
Well, this is really
versus
interesting.
him trying to pay for 9 months.
I was going to accuse you all of being too soft-hearted, but the last thing that you said just then, I think, has got to come back into the equation. So here's what I was going to say. Um, if any tenant could, whenever he wanted to, get out of an obligation simply by waving the magic wand of disability, no sensible landlord would ever rent to anybody.
Yeah.
And so, I'm a small business person, and now I'm not going to be able to pay my mortgage, and I'm not going to be able to pay my employees. If this keeps happening, that's terrible. So I think the idea that Bob should be let out entirely has to be viewed through this lens of, does it impose an undue financial and administrative burden on the landlord? If it's mom and pop, I think he's got a much harder case. If it's the 500 unit, sophisticated management company, maybe he's got a better shot, but it still feels to me like, isn't Bob cheating somehow here? I mean, we could be soft-hearted for Bob if we wanted to, but he's asking to be able to walk away. No other tenant would be able to do that. So that sounds a little unfair. That's what I was prepared to say. So anybody want to come at me for being a hard-hearted landlord?
I'm gonna fight for Bob again and say Bob is like I said, he has um only so much money. He has nothing in savings. We are very sorry that it happened. But if we have to, could we just buy out a couple of months instead of the full 9 months? And
Mhm.
maybe that would help you some.
And I do think, I mean, it depends on what your rental market looks like. If you could really if the landlord could refill the place in 30 days, then I think the law probably says that is mitigation, right? The landlord would be required to mitigate. Couldn't just sit on her hands and wait 9 months and charge Bob the whole thing. She needed to make efforts, and maybe Bob would also help to find a new tenant. So maybe there's one of those interactive process conversations that you could have to get to a reasonably good thing. So Bob doesn't get the Cadillac of being let out entirely, but maybe
Mm,
Bob gets the Chevy, which is to say he's got to kick in a little bit, and maybe the other side can kick in as well.
right.
Okay. Uh, Before we go on to the next one, does anybody have real life, have we prompted any sort of real life questions that people want to pose? Like, I have dealt with this before, either from the housing providers side of the equation or from the tenant side of the equation that might be just as useful as another hypothetical.
And I would like to reiterate that everyone has the ability to unmute themselves if you have any questions.
Okay, well, I'm conscious of the fact that we have maybe 5 or 8 more minutes left before we're going to let people go. So I'm not going to consume all the time. Let me just see if let's do this one. Um, okay, my daughter has a respiratory disease. She needs a home health care aide. Um, I live in a mobile home park, and parking is limited here, right? And so one way that the park tries to keep down, the traffic and the parking is they charge fees, a guest fee and a parking fee. I can't afford to pay this fee for the home health care aide. She can't afford to pay it because, as we all know, people who do this work are drastically underpaid. Uh, would the landlord be required to waive those fees for the benefit of my infant daughter? Happy to have somebody take this on.
I think that would be a tremendous help to waive the fee due to the circumstance and the situation. And because like trying to pay it is gonna just be too much. But maybe see if a letter or something maybe could get wrote so that it have documentation, the reason why, if it ever came back, asking why the fees weren't paid. So maybe get something from the doctors stating that they're in need of this aid. And maybe the doctor maybe get a doctor's note maybe involved in it so that the fees can be waived.
Sounds good. Other thoughts? I do think that the relatively low amount here, as compared to the waive 9 months of rent, makes this a much stronger case from the perspective of the tenant side. From the quality of the accommodation request is much stronger in the evidence. Presumably, if you had that doctor's letter or something else like that, um, you know, if not for the waiver of these fees, my daughter might have to be hospitalized or something along those lines. Really sort of, support the accommodation request showing that the benefit is very high to the family and what's being waived or lost in terms of fees on the part of the housing provider is very low. I will tell you that as simple as this should have been, this case went to the U.S. Court of Appeals for the Ninth Circuit, so one step below the Supreme Court, not once, but twice in the 1990s. And the court made decisions 2 times. The second one was even stronger than the first. And it said basically, duh, no undue financial administrative burden, no fundamental alteration of the landlord's services. This should be done. And this has been a sort of important leading case over the last 25 or 30 years for folks with disabilities, both in the Ninth Circuit, which is most of the West Coast of the United States, but also in other parts of the country as well. The last thing I want to do, just where we're talking a little bit about accommodation, and then I'm happy to turn the floor back over to Ashley, is to say this. In the space of reasonable accommodations, which has everything to do with how does this particular tenant benefit and does it cause an undue financial or administrative burden for this housing provider, there are a million variations on these cases, right? In fact, the largest number of fair housing complaints filed with state, local, and federal agencies of any is about disability, and among those about accommodation. So 30 some years after the Fair Housing Act was amended, we're still having a lot of problems with people not getting their rights observed and not get their rights enforced. But when they do go to an administrative complaint or to court, many of these cases are winning. And it's a shame that they have to go that far. Part of the resistance is that, going back to that thing I said at the beginning of my presentation, which is the idea of accommodations still don't fully land in the housing provider community. There's a lot of confusion about it still, or there's a lot of resistance to it. Part of the confusion is we just don't understand why people with disabilities should be treated differently because we've been told all along we shouldn't treat anybody differently. And the other part is, oh my God, if I give her the thing she's asking for, everybody's going to come here asking for one. And I'd rather just shut down the conversation than, do what I'm supposed to do. That almost always gets landlords in trouble. In any case, it's been delightful spending some time with you here. I work for a law firm that has a national practice of anti-discrimination. Most of my time is spent thinking about big and small matters involving people with disabilities. But if I can ever be a resource to anybody on this call, feel free to drop me an email, and happy to noodle things out with you. So Ashley, back to you.
Okay. Thank you so much, Michael, again for today. This was very informative. And as you stated, this is a lot of the work that we also see at MCJ in regards to violations of the Fair Housing Act in regards to disability. So no matter what we do want to make sure that we, at the very minimum, make sure that we let people know about disability rights. Again, I would like to thank you for joining us today. Thank you, everyone who participated. A special thank you to Ms. Regina Smith and Sharmika Curry. Please email Ms. Smith and Ms. Curry. Please email the housing email address, housing@mscenterforjustice.org. And we're going to send you some swag for stepping up and participating today. So we do thank you for that.
Oh, thank
So
you.
thank you. So make sure
Okay.
you email us so we can put that in mail. So it's the housing@mscenterforjustice.org. If you email us, we will make sure that we will get that in the mail. So thank you for stepping up today for participating.
Thank you, representing Lar Housing.
Okay. Okay, so our last session will be next Thursday, same time, same link. And we will talk about criminal records and the Fair Housing Act. So we will see you guys again next Thursday for our last session. Thank you again, Michael, and thank you all again for participating. Thank you so much. Have a great rest of your
Thank you.
day.
Be well.
All right.
Thank you.